Good afternoon, everyone. Thanks for joining us today for our webinar on the independent dispute resolution process. Today, we're going to focus on some program updates and a few reminders for our facilitators. I'm your host, Ben Gonzalez with TDI's Public Affairs Division, and our presenter today is Marcus Wilcox. Marcus is the manager of the Independent Dispute Resolution Group here at TDI. And joining Marcus today for the Q&A will be Cindy Wright, the director of TDI's Consumer Protection Office.
Hi, everybody.
Good afternoon.
And also Robert Simons from TDI's General Counsel Division. Robert's the assistant director of the Office of Policy Development Council.
Good afternoon.
All right, well, we'll turn it over to Marcus for a short presentation to get us started, and we'll take some questions after that. Marcus?
Thanks, Ben. Appreciate everybody joining us today. So a lot of the information I'm going to share today is, already old hat for everybody. So I'm going to do my best not to bore you to tears, but there are a couple of things that I need to, or that have come up over the summer or the last couple of months that we wanted to share. So like I said, I'll start off by sharing some information that I'm sure everybody's already familiar with. And then, we'll cover some things that have come up recently. And then we'll make sure that everybody has time to ask some questions at the end. So going to go ahead and share my screen with you guys. All right. Go ahead and get started here. And again, I'm sure for all the facilitators and a lot of people that have been part of the program for a long time, this information, again, I'm sure it's old hat for everybody. It's been covered 1,000 times, but we'll just go over it quickly. So one thing that we've seen over the past couple of months is mediations have gone over the 180-day period. So as we know, per statutes, mediations have to be wrapped up in 180 days. That is the resolution deadline. The report has to be filled out within 45 days after the mediation is held. And, agreement will not always be reached, at the mediation conference. So we've received some questions about that recently, and we do want to make it clear that, all parties, meet, but there may not be a resolution that takes place. As we discussed, the mediation does have to take place within 180 days. The report has to be filed within 45 days, and an agreement doesn't necessarily have to be reached at the mediation conference. Arbitration, of course, the timeline is a lot shorter. We have 51 days to the resolution deadline. The arbitrator must notify parties of the final decision and file a report in the portal by day 51. And the binding resolution cannot be changed. So we have had some questions about that over the summer, and that is something that we can't do. So once the binding resolution is submitted, no changes can be made per statute. So we want to talk a little bit about bad faith. So we do have some bad faith language that is in the statute that we work to enforce. So for either party to failing to participate in the informal settlement conference or arbitration mediation, both with both tracks, there is the expectation that people participate in the informal settlement teleconference. We don't dictate how that particular conference takes place. Different parties do it differently, but the expectation is that that settlement conference takes place. Also, failing to provide the information that the mediator or arbitrator needs to make their decision, that's an issue that we've been dealing with. So we want to make sure that the facilitators have all the information that they need to make the best decision. Also, there is the expectation that a representative is designated who can make the decision, that has the full authority to enter into an agreement. We also expect that both parties communicate with the facilitator, and if parties are not communicating with the facilitator, we do consider that bad faith. And, we say you're failing to provide the information, because if you're not communicating, then, how can you provide requested information? So when it comes to bad faith participation, we work with our partner agencies, Health and Human Services. They are over facilities, and the Texas Medical Board, they regulate providers. So we've set up a working group. We've had some discussions with both agencies, and we work with them when we identify some bad faith participation. The one thing that we ask for from facilitators, that if you maintain records showing the communication that you've had with the parties, even if it's just an indication of parties not responding, we'll request those records, and we will forward them on to either the Texas Medical Board or Health and Human Services when we reach out to them regarding any kind of issues that we've identified where we feel that bad faith participation is happening. So those documents help us, and they help the agencies that have regulatory authority to take the steps that they need to take to try to get the situation resolved. A question that we've had come up over the summer is the fees are per request. So as you know, some requests may only have one claim, some requests may have multiple claims. It kind of all weighs out. So there may be a situation where you have a request that has more claims than not, and you're like, wow, I'm just overwhelmed. Like, I have all these claims that I need to look at, but I'm only being paid to look at one request. There could be a future request where you only have one claim. So the thought behind that is it should all balance out in the long run, but the fee is, per request, regardless of how many claims that are in that request. So the mediation and the arbitration has to take place even if the fee isn't paid. So I understand that it can be frustrating that if you haven't been paid for your services, but again, there are statutory deadlines involved. So we need that mediation and that arbitration to take place. Now, if you're not paid for your work, definitely go ahead and note that in a portal. Make us aware of it, make the IDR team aware of it. What we'll do is we'll reach out to the party and, or parties, and let them know, hey, the facilitator has not been paid. We also have some additional contacts that may not be visible for you. And if we have them, we'll certainly reach out to them, make them aware that there's a problem, that facilitators have not been paid. And we will try to make sure that, you receive what you're due. Now, we can act as a collections agent. Unfortunately, we don't have that statutory authority. But like I said, we will do our best to make people aware of the fact that you haven't been paid. And, in some cases, we reach out to someone and say, hey, we noticed that you haven't paid the facilitator. And they may send us some information showing, hey, we mailed the check that day, or we made the payment that day. In some cases, I guess the proverbial check is in the mail, but we do, want to make sure that people get paid. So we can't enforce any kind of collections effort, but we'll certainly be happy to reach out and notify people, hey, payment is lacking. And you as a facilitator can take any kind of action that you feel is appropriate. Some people have told us that they've worked with collections agencies. Some people have decided to take legal action. There isn't anything that says that you can or you can't do that. So, we feel it is appropriate for you to do so if you feel that is something that you want to do to make sure that you receive your payment. One thing I'd like to share is we do have new health plans coming on board. We have new, submitters coming on board. And one thing that I share with them always is to go ahead and get all the paperwork out that you need to the facilitators. any type of paperwork that they need signed in order to set up a payment, make sure all the tax information is sent. Because I always tell the parties that eventually you will get assigned all facilitators that are in rotation. So in order to try to avoid issues with payment, I usually should suggest, when a new party comes on board, that they go ahead and reach out to everyone and get everybody in their payment system or whatever it is that they need to do, so that process works as smooth as possible. We've seen several situations where parties have tried to withdraw after the request is assigned. I always make it clear to folks, there isn't a way to withdraw after the request is assigned. And really, it doesn't make sense to withdraw after a request is assigned, because payment is due upon assignment. So at that point, the fee is already due. So you may as well go ahead and let the process play out at that point. I guess, for a lack of a better term, once it assigns, you have nothing to lose. So there just isn't a way to withdraw, an option to withdraw a request once it's assigned. Once it's assigned, it's assigned. So again, I always encourage people just to go ahead and let the process play out. We've had some complaints filed against health plans, and parties have felt that if a complaint is filed, that kind of brings things to a halt. It doesn't. So even if a complaint is submitted, again, there's still statutory deadlines. That request is in the system. If it's not withdrawn, then it just needs to go ahead and move forward. Same thing, we've had some parties over the summer take legal action against each other. Again, if they've submitted the requests prior or during that time period that they've decided to take legal action against each other, again, everything should move forward as normal. Those requests still need to go ahead and be completed. Any type of separate legal action outside of the IDR process shouldn't impact the IDR process in any way. And again, our expectation is that once the request is submitted, that the parties will follow through in good faith. Again, we've made people aware what bad faith participation is. So our expectation is that everybody moves forward and makes the process work the way it's supposed to. Again, this kind of does fall under bad faith. So if parties are unresponsive, please let us know. We will attempt to contact the parties. Please continue to contact the parties as well. We've all had, I think all of us have been impacted by COVID in various ways. So I've spoken to several, both health plans and submitters over the summer that have been impacted by COVID. And, certainly we want to be empathetic, sympathetic, but, people do need to respond. So, if they're not responding, certainly let us know and we will do our best. But we also ask that you continue to contact the parties as facilitators in an attempt to get them to respond. As we mentioned with the fees, we do have some additional contact information in many cases. So we will reach out to every contact that we have in order to get parties to respond. I've also reached out to some of my peers throughout the agency. They sometimes have, additional contacts with health plans. We've reached out to, our partner agencies, TMB. They assisted me in one case getting a hold of someone that they had. And, we were able to get some things worked out. So like I said, we will make every effort that we can to get uncooperative parties to respond. But again, we ask that you do so as well. And if there are any issues that you run into with emails bouncing back, please let us know right away. We've seen some situations like that, and we've reached out to the submitter to work with them to get these issues resolved. We even had a situation where we had the submitter, their IT group, get into a meeting with our IT group to get that situation resolved. So there may be situations where you see it before we see it. So if you do come across that, please let us know right away so we can reach out to the party and try to get that resolved as quickly as possible. Some of the best practices that we see that work well for facilitators is just try to contact the parties as early in the process as possible. We know the mediation process is long. We see it definitely a lot more with mediations than arbitrations, but sometimes, with that longer time period, it just kind of gets away from people sometimes, both facilitators and, the involved parties. Sometimes it's just kind of slips to the back of mind, kind of out of sight, out of mind sometimes, even though we send those reminder emails. Sometimes you think you just have a little bit more time than you actually do. So, again, we would suggest that as early in the process as possible, you reach out to the involved parties. So, again, if there are other contacts that you've dealt with in the organization, it's always good to contact other folks as well. Because like I said, we've had some people tell us like, hey, the person that we normally deal with was unexpectedly out of the office, or they had this going on or that going on. So if you contact additional people, we found that, generally somebody will respond, even if it's not the person that you're looking for. But, they may be able to give you an update saying, hey, this person is out of the office until then, or something along those lines. At least they'll be, in contact with you. And again, notify us if you have any issues. I tell people all the time, the IDR team is small, but they are definitely on top of things. So if you see an issue, let us know, and we will reach out right away to again, try to assist in getting some things resolved. We've over the summer, we've seen some issues with the data. The data can be kind of challenging for us because it's our data. We, I guess, own the data, for lack of a better term, but we don't necessarily control the data, right? So we have facilitators entering information. We have submitters entering information, health plans entering information, and there are times when information isn't entered correctly. And so we have to work with the parties to try to get that resolved. So from your end as a facilitator, don't enter 0 as a final offer. There's always going to be some sort of offer, right? 0 should not be a final offer amount. So we also ask that you verify the amounts offered by the parties. We have seen it on occasion where the health plan doesn't enter the informal teleconference information. We've been working with health plans on that. Or, if the submitter says, hey, the health plan did not enter the correct information. So again, we try to work to get that resolved, but sometimes we're not made aware of it until after the fact. So if you go into the portal and you notice the information that you're provided in the position statement doesn't match what you see in the portal, you can always, verify those amounts with the parties. If there's a disagreement, so if, for example, the submitter says, hey, this is not the amount that we agreed upon, we encourage that you say, okay, you ask the submitter, hey, if you're telling me that this is not the correct amount, what is the correct amount? Can you send me some information? Is there some communication that you have between you and the health plan, preferably dated, showing this is the amount that is agreed upon? So, the parties can continue to negotiate even after the informal teleconference. So the offers may change. They may have one amount on day 30 and a different amount on day 32 or day 33. And that could happen before you have a chance to get in the portal and, take a look at that information. So we ask that that's something that you take into consideration. And if you see a difference, again, reach out and see if you can't figure out what that difference is or what may be causing that information not to match up. And then if the parties settle outside of mediation or arbitration, let's say they settle on day 32. Once you get that information provided to you by the parties, as long as both parties indicate that that is the case, you can simply go into the portal and indicate that on your report that it's settled at arbitration or mediation. If that is the case, just keep in mind that you still should get your fee. Again, the payment is due upon assignment. So, if the parties settle on day 32, you should still get your fee. Over the summer, we have been asked to extend resolution deadlines. In some cases, people have used the terminology, reach out to TDI to get the resolution deadline extended, things of that nature. That's not something that we're able to do. So the resolution deadline can only be extended by agreement between the two parties. So one party would go in and enter the extension, and the other party would either accept or reject the extension. There's nothing wrong with accepting or rejecting. So we've had party contact us say, hey, it's not fair. Marcus rejected my extension. He's the exception to the rule. Everybody else always accepts my extension. Unfortunately, we do not have any control over that. That is a determination made between the two parties. Again, we understand that things happen, especially with COVID and the pandemic, but we can't force someone to accept an extension, and we can't force anybody to reject an extension. So again, that would be a determination that is made between the two parties. Again, we're just asking that that the reports are submitted by the resolution deadline. We do look at the past due deadline. We look at it daily. We look at it and then we'll reach out and say, hey, just a reminder, your report is past due. Again, we're not trying to harass anybody. We're not trying to be inconsiderate that you may have something else going on, but we're just trying to send a friendly reminder. And again, it's something that we need to do because those deadlines are set in the insurance code. So we're just trying to make sure that the system runs as smoothly as possible. Ultimately, it is your responsibility as a facilitator to make sure that the deadlines are being met. But between the portal and the IDR team, we're just trying to make sure if we can help you with that, that you're able to get those reports in on a timely manner. So facilitators are put into selection when the request is created. So, as most of you guys know, the system will assign 5, facilitators to a request and go from there. We ask that if you need to take yourself out of rotation for any reason, definitely do so. So taking yourself out of rotation removes you from all requests. So it doesn't just remove you from future requests, it also removes you from, if you had the potential to be assigned to a request that was generated 25 days ago and is getting ready to assign, it'll remove you from those as well. That is because we want to make sure that if someone has an emergency situation and they remove themselves from the rotation, that they also get removed from the previous request. Because again, if there's an emergency situation, we don't want a request to assign 5 or 6 days later when you've taken yourself out of rotation and all of a sudden you're dealing with whatever situation is you're dealing with in your life, and you get a request assigned, and now you have to figure out how to deal with everything that you're dealing with and also get a request taken care of. that, you have a time limit. So again, it's not to be punitive. It's not to be mean-spirited. It's just, we want to make sure that if you're taking yourself out of rotation for any reason, that you're removed from all requests. So, and then being put back into rotation would then only put you back on the selection list for newly created requests. So again, let's say that you are assigned or you're selected for a request that's at day 25. If you remove yourself from rotation and then the next day you're like, oh, okay, my situation wasn't as bad as I thought it was, let me put myself into rotation, you would not be put back on the selection list for those requests that are already created. It would just put you back into the new requests only. So what I like to tell people is, if you do that, one thing that you want to keep in mind, just be sure when you're removing yourself out of rotation, because if you think about it, that will remove you for 30 days, because you can only be assigned, requests that are newly created. They then have to go through the 30-day period. So even if you take yourself out of rotation for 1 day, you would not see any assignments for 30 days. So, just something, I want to put out there, because again, I want to be fair to everybody. I'd hate to see someone take themselves out of rotation because they have something going on for 2 or 3 days, and then wonder why they haven't been assigned any requests. Since we're speaking of assignments, I also want to address that we have a lot of requests that are coming through, but we are starting to see more requests settle prior to assignment. So the way the portal is set up, it's to make sure that everybody gets the equal amount of opportunities. So if facilitator A has, 10 requests that settle, and facilitator B only has 6 requests that settle, facilitator B may receive more assignments. But again, we're only concerned that everybody received the same 10 opportunities. That's the way the portal is set up. We can't control anything that happens prior to assignment as far as if the parties settle or not. So again, if you know anybody that's a facilitator and you guys are comparing who has how many assignments, that's not the most accurate way to do that. Again, behind the scenes, our IT team, our developers are checking to make sure that everybody has the equal amount of opportunities. We can't determine what parties are going to strike, and we can't determine whether parties are going to settle or not. So again, that doesn't give us control over who gets assigned what. We just make sure that everybody gets equal opportunities. So having said that, there may be some time period where you don't receive an assignment. Again, it's not for any particular reason other than, requests may be settling, but it's not because of anything that we're doing. So I've actually had a facilitator ask me, did I do something wrong? Am I being punished? It's nothing like that. Again, it's something that we don't have control over as far as the assignments themselves, whether the request goes to assignment or not. Obviously, summer is about over. My son goes back to school tomorrow. I'm extremely excited about that. So, we've had people travel outside of the US. We just asked, if you do travel outside the US, please take yourself out of rotation. We've had some issues with that this summer. We've had people contacting us asking if we could, complete their assignments for them. That's not something that we're able to do. So if going forward, if you're going to travel and you don't think you'll be back in time, or if you're going to be out of the country for an extended amount of time, just please take yourself out of rotation prior to your travel. That way you don't get assigned any and run into a situation where you cannot access the portal outside of the country. We ask that if you travel within the US, or if you use public internet, just take security precaution. It's all the stuff that we've heard from our banks and our credit cards, right? Just try to avoid using public computers. Don't just log on to random Wi-Fi that may not be secure. If possible, use a VPN. Those are all things that should kind of help you avoid any type of issues while trying to log on to the portal. Password resets. We all have a million passwords in our lives, right? Like I can't even count how many passwords I have that I deal with on a daily basis. So we know there are going to be password issues. We know that are going to be where you're like, hey, I know this password is supposed to be this, and it just doesn't work. If you have any password issues, definitely let us know. Just keep in mind that when we reset passwords, it needs to cycle through the database. So if you call and speak to one of the representatives, it's not something that's going to be able to be reset in a minute or two. Same if you send an email, it's not gonna, as soon as you get the email back saying, hey, your password has been reset, it's gonna take a little bit of a time. So, just give it about 10, 15 minutes. Once you get that email saying, hey, your password has been reset, just give it a little bit, then go ahead and log in and it should work fine. We have seen some situations where clearing the cache or just getting rid of those cookies will resolve some of those issues. Again, I think I proved at the start of this meeting, I'm not an IT expert. So, not sure why clearing the cache and the cookies helps, but it does. We've definitely seen it work. And the portal does not necessarily like Safari browsers. So we've seen people have issues with Safari. Again, I'm not 100% sure why. It's not that we favor Chrome or anything else, but in this case, we do favor Chrome. So if you have issues and you're using Safari, the first thing I would suggest is just go ahead and try a different browser. A lot of times that'll take care of the issue. We were contacted over the summer. Some mediators were told that TDI told the parties that a mediation conference doesn't have to take place because they've reached the conclusion that it's not a good use of time, that it's just not going to work. Mediation won't do anything. So just go ahead and, scratch it. So the statute is clear that the parties have to participate. So, if someone tells you, hey, TDI says this meeting doesn't have to take place, please push back on that. Please let us know. And, if there's a misunderstanding or if there was some kind of miscommunication, we'll be happy to reach out to the party and let them know, hey, no, this must take place. So as a facilitator, it's your responsibility to make sure that the conference is scheduled. We don't try to tell you how to do that. We just want to make sure that it is scheduled. So again, as I mentioned earlier, reaching out as soon and early as possible can make a difference when it comes to scheduling this. I know I've spoken to not just health plans, but submitters as well that are saying like, hey, we're having 3 or 4 of these a day. And I just tell them, hey, the volume of requests is increasing. So you may have to do multiple meetings in one place, on one day, and, just work with facilitators to make sure that you get those scheduled. So again, if you have issues getting those scheduled, let us know. But, ultimately, it is your responsibility to get those scheduled. And please don't just say not settled without the conference taking place. We had an issue, we got it resolved, but it does cause some problems. And the reason it does cause problems because it is a legal issue. So the way the statute is written, that the mediation has to take place before the parties can take legal action. So I guess it would be an awkward situation if people move forward, take legal action, and then the question comes up, did the mediation take place? What was discussed? And then it turns out that the mediation did not happen. So please make sure that the mediations are scheduled and the conferences take place. Again, we ask that all 10 factors are taken in consideration. This is outlined in TIC, so it has to happen. And again, I've had conversations with both health plans and submitters that say, hey, I'm 100% sure that the 10 factors weren't used in this decision. And I always push back and say, facilitators know that the 10 factors have to be used, and and I leave it at that. So there is still some confusion around how the arbitration works, and I explained to everybody that the reasonable amount is determined for services rendered. So again, when people say how was this conclusion reached, I let them know it was based on the 10 factors. It's based on the position statements, and that is how the facilitator determined the reasonable amount. Once the reasonable amount is determined, the party who wins the award is the party who made the closest reasonable amount. It's baseball style arbitration, and that's always the way I refer to it. So I let them know the binding award amount is closest to the reasonable amount. That is the amount that the facilitator has determined, and I move forward. Again, I'm not here to second guess anyone. We just want to make sure that the process moves forward. And I also like to point out, if there is bad faith participation, if people aren't providing you with the position statements that you need, they can be ruled against. You don't have to have both position statements. If only one party provides a position statement, you can use that position statement to make your determination. Again, sorry, I think I just covered that. So again, if the party doesn't send the requested information, definitely use the information that you have to make your determination. TAC will back you up on that. And the arbitration determinations, they can't be altered. So once the parties are notified that, hey, this is our decision, we can't go back and make those changes. That was actually put into statute to, protect the facilitators. So, Fair Health is selected as the benchmarking database. That was determined when this program was first created. So, I know there are some questions about that, so we'll definitely speak to that. But that is, the benchmark, the benchmarking that we use, and we will continue to use that going forward. I prepared some data. The good thing is you guys were already able to see one slide ahead, so I'm sure you've already seen this data. But I want to make sure that everybody has enough time to ask the question. So I'm just going to go ahead and skip ahead. This presentation will be posted, but here's just some information that I wanted to share. But I wanted to make sure that everybody has enough time to ask their questions. So I'm going to stop sharing my PowerPoint here, turn it back over to Ben, and then Cindy, myself, and Bob will be able to answer some of your questions.
Perfect. Thank you so much, Marcus. I think we probably answered some of those questions with the presentation, but any questions about a specific company, we'll need to answer those offline. So you can email those to idr@tdi.texas.gov. So any questions we don't get to, email those again later to idr@tdi.texas.gov. All right, Cindy, Marcus, Roberts, let's jump into the questions. First off, which is the more preferred method, setting up the date and time for the mediation, or starting by asking the different parties about their availabilities?
I guess I can answer that one real quick. So we don't really have a preferred method. There are some times when I do go into the IDR box and just kind of look through some of the emails that we receive. And we've been copied on some of those. What I find works a lot and works well is if the facilitator sends like 3 or 4 dates and lets the party choose from those. But that's completely up to you. If you just send an email that says, hey, I expect you to be here at this time and this date, the parties might respond that they're not available at that time. But, providing options seems to work fairly well, but it's completely up to you. It's not in statute, so we don't have a rule on that.
Okay, sounds good. So multiple choice may work there. Here's another question about Fair Health. There seems to be or have been a substantial drop in the allowed amounts as reported by Fair Health? Do we know what's happening there?
Cindy, do you want to tackle that?
Yeah, sure. Well, I mean, I guess a couple things. One of them is we all know data is always changing, especially when we're running through in this program, the volume that comes through. But, in general, once the law was implemented, we would expect the needles to move once more data started, coming into that system with respect to both the 80% of billed and the 50% of 50th percentile of the contracted rates. I mean, we think, so here's the, the assumption is that, both Senate Bill 1264 and the No Surprises Act are probably pretty significant factors in that number changing. We would assume that the reduction that you're seeing in the 50% tile would be is sort of showing what the market's doing since both of those laws were implemented. We don't know for certain. TDI doesn't control the Fair Health data. All of the health plans, as far as we know, so the reporting isn't mandatory into Fair Health, but we believe that all of the health plans that are processing through IDR requests are providing their data directly to Fair Health. I think one more thing I would like to add is that we have the balance billing prohibition report is something that comes out every year. And so toward the end of the year, you'll see that come out. The data in that report will involve IDR specific data. So not just all claims, but IDR specific data. And then it's also going to show contracting trends within Texas. So that's something to kind of look forward to. We'll publish that on our site too. I know that's not directly tied to Fair Health, but it's certainly related. So we wanted to point that out. I don't know if you guys had anything to add to that, but yeah.
Okay. Then I'll move on to the next question. Mark, as you described a couple of different scenarios about negotiation stalling, but is there a procedure for reporting a participant as non-cooperative and also for reporting failure to pay? What's the procedure?
Yeah, just send us an email. Again, you may get an email back saying like if the person isn't cooperating, like I always have the team ask for any kind of communication that's taken place as far as maybe emails that have gone back and forth or just emails that were sent out saying, hey, I still haven't heard back from you, trying to set this up. And then again, I forward that to whichever agency to try to, work on getting the situation resolved. And, we'll also reach out and again, try to use any type of contact we have. Same thing with failure to pay. We'll always reach out to the person or entity and let them know, hey, Ben told me he hasn't been paid. Can you please take a look at that and let us know what the problem is?
Okay. And this one's similar along the same lines, kind of technical details of how things work. What do you do when you can't get the parties to schedule before the deadline approaches?
Again, let us know. We will let the parties know. I always point out, I'll include, or the team will include a link to the, tick saying, hey, this is again a statutory deadline. We just didn't choose this random number. Mm-hmm. And again, we ask that the facilitator continue to reach out to the people as well. And just keep hammering away and hope for the best. But if they don't, if they don't respond, again, we will make sure that the appropriate agency is notified of what we consider bad faith participation.
Okay, thank you, sir. Here's another one about Fair Health. Is TDI going to offer any training about using the Fair Health system since it's so integral here?
Cindy, do you want to be the Fair Health go-to person?
Sure, I'm happy to. Well, last month, Fair Health actually, I think all of the arbitrators, that are on the commissioner's list at TDI were invited to a presentation that Fair Health made earlier in I was about to say January, but it's way too hot for us to think it's January, in July. We're working out a couple of technical glitches because it was recorded and they're happy to make that recording available to us. It's just going to take us a little bit more time to get that posted. So we just ask for your patience, and and I kind of like to put in a plug for the Fair Health customer service. Those folks are really responsive also. So, to be honest, far and away, most of the time when it comes to a Fair Health question, we're going to say, ooh, we don't know all the inner workings of that program. So the best thing to do a lot of the time is to reach out directly to them, and they're happy to answer. But we can certainly help facilitate that if we need to. So.
Okay, thanks, Cindy. Here's the next question. What if an arbitrator keeps getting stricken? Does he or she have to go to the back of the line if they're stricken, or does the system quickly put them back on the list of 5 right away?
Yeah, so it'll depend on how many requests come through, right? So if you're, if you get a strike, you could go back right away, or it could take a bit of time. It just depends on how many requests come through. With this volume that we have coming through, like last month, we had over 30,000 requests come through. You're not going to see a big lag right now. You'll be back on a request very quickly.
Okay, sounds good.
Wait a second. I was muted.
Sorry, I didn't see you.
I would like to pull back the curtain too a little bit, if you don't mind, Marcus. I think just in everyone's view of the portal when they're logging in, you don't kind of see some of the things that happen in the background. And so just want to kind of give you a little bit of a picture into the inner working, so to speak. So every single time a request is submitted, it generates a list of 5 every single time. So if you think about the volume that Marcus was just saying, 30,000 times last week, a list of 5 was generated. The order is random, but it's tends to stay the same. Now it tends to stay the same, aside from when people remove themselves from rotation and insert themselves back in. And on a slow moving system with not very many arbitrators or mediators in the list, you would expect to have that for that to have more of an impact, but the volume is so enormous that it levels itself out. And so we look at it like 2 parts. Part 1 is the lists of 5 are spun off every single time a request is submitted. And then immediately that list is available to the parties to make their strikes. And then, of course, at the end of day 30, then whatever is remaining, there's a random choice from that if they haven't automatically landed on one together. So the strikes are kind of independent of the list of 5 generator. So we're really confident that everybody's got an equal chance to show up on a list of 5. What we don't know is things that aren't under our control, which is why are they striking one versus another? Do they not like the name Marcus? Do they prefer the name Bob? We just don't know that.
Okay. Moving on to the next question here. This is about a specific situation that they encounter. It says, on the issue of bad faith, it's not unusual for us to not receive any information from one party or the other. There's no place to enter that on the portal. Are we to report that somehow anyway? A few times neither party has sent us anything.
Yeah, please let us know about that. Again, both parties, have responsibilities in this process. So yeah, if someone's just entering a request and not responding, or if the health plan is, not looking at what's going on, not looking at the emails that they're receiving, then we need to know about that. Certainly when it comes to the health plan, we'll address that. And, again, when it comes to submitters, we will address that with TMB or HHSC if that's an issue.
Okay, sounds good. Next question. Is there a way to update the payment information that's already been sent to the parties?
That would be, that's between the parties. So, if you have I don't know if you want to change your checking account or whatever, we don't have that information at all. So, just contact the parties.
Okay. Do we know who the new health plans that are coming on board, who they are?
That we don't. A new health plan reached out to us last week that said they are looking to gear up to come on board, but I don't know that until they reach out to us.
Okay, sounds good. Next question. My fees have been more than the settled amounts in some cases. Is there an algorithm to match cases to the fees?
No. So yeah, every now and then I scratch my head too when I'm like, okay, you spent $600 to win 20. All right, moving on.
Next question. If fees are not paid by a specific facility or health plan, can we as the mediator block future work with that specific party?
That is something that we can't do because, again, the assignments are random. We don't have any control over that. But if it's to the point where, again, please let us know. We can't do any kind of collections, but we can do the best we can, again, working with those other agencies, trying to make sure that you get your money.
Okay. Can you ask the parties to send a notice of payment along with their case number when using electronic payments? It's become a huge task to try to match those up, and no, there's no notice as to which case and which party has, and there's several cases assigned to me, but I only see these payments for the 3/4 of those cases, and then we mark it as paid or not paid over email for the month. So can we have some kind of identifier there?
I would definitely say you as a facilitator, feel free to ask them, if that's the expectation that you have, please let the parties know that your expectation is that, when they pay you, that you're notified what request that's for.
Must have the case number there.
Mhm.
So you can set up your own system there. Next question. To clarify, in arbitration, are we supposed to be paid per claim? So if there are 4 claims and 1 request ID, are we supposed to be paid for each one?
Per request.
Per request. So
Yeah. So it doesn't matter if there's 1 or 4, it's per request.
Okay. Can we as arbitrators suggest that the parties may request an extension even after we've been assigned if they agree?
Bob, you want to take that?
Sure. Yeah. So the timelines, the turnarounds are very short. That's what the legislature requires by statute. So do the best you can. Do the best you can. Let's say that. I suspect that it's not always possible, or it doesn't always happen. I don't think we've ever taken any action, but just do the best you can to get those tightened. And I think, as Marcus mentioned in his presentation, I think sometimes the reason folks have trouble meeting those incredibly tight deadlines is because they're waiting for one party to present the information that they had requested. And if you've given them a due date, a reasonable due date, and they have not provided you that information, you've done what you've needed to professionally. Do the decision, make the decision as best you can, take account of factors. The fact that they did not present information that might have helped their cases is more on them, reflects on them, and not on you. And just do the best you can.
Okay, thank you, Bob. If a party has not paid, do we have to mark them as not paid, or can we waive the fee?
That is up to you. You're the one receiving the payment. If you feel there's a valid reason why they don't have to pay you, that's totally up to you.
Okay.
I just don't want Cindy to think that I'm willing to work for free.
All right, we'll talk about this later.
Yeah.
Is there a limit on the number of extensions? If not, why not?
Bob, first of all, let me say there is not, but maybe Bob can speak to.
Yeah, and I'm wondering if this probably is more mediation related. So there is a distinction kind of between the mediation and the arbitration process. And the mediation is much more, try to get the parties together and see if they reach an arrangement. But there's no shotgun weddings in mediation, right? It has to be voluntary. And so if folks want to keep extending, if that's probably fine. With the arbitration, of course, the deadlines I think are a lot shorter and kind of statutorily prescribed. So with mediation, there's probably a little more flexibility there with the extensions.
I'd like to add one more thing to that, and that is from the participants' perspective, every now and then we'll come across, a situation where the participants believe that by extending deadlines, once the assignment's been made, then they won't have to pay you, or they can sort of delay something that's already taken place. If the parties can extend, unlimited number of times, provided that they agree, but once the assignment is made, all that's effectively doing is giving the mediator or arbitrator potentially more time. That doesn't, it doesn't mean that they're not supposed to pay upon assignment, just like, they still have to participate in the same ways. So just wanted to add that.
What happens if you have already paid and you've already been paid and then you take yourself out of rotation?
The expectation that if you've already been paid, that means the request has already been assigned. So if you take yourself out of rotation, again, that's only for potential assignments, right? So if you've already been paid, the expectation would be that you work that request. But if you're not able to, if something catastrophic happens, we certainly understand, we can work with you about refunding the money and then reassigning the request to someone else.
Okay. Next question. Do parties actually exercise their right to strike arbitrators, or do they forego that and let TDI do the assigning?
No, parties definitely strike.
All right. Next question. Can we do mediation conferences online, like via Zoom?
Bob, you want to address that?
I presume that's probably been how most of these have been happening the last couple of years, right? So yeah, we understand. And I think do what you can be to be efficient.
Okay. I'm seeing more providers argue that fair health is not accurate for a variety of reasons. Let's see here. My sense is that the statute does not authorize us to consider those arguments or decide for ourselves whether it's accurate. Is that correct? We just go with fair health?
Yeah, so the way the statute's written is that there is a single data collection entity that the commissioner has identified that is chosen, that was chosen to be fair health. So that is the entity through which data comes. And that's, yeah, for better or worse, that is not a decision that you have to make, right? You use fair health because that's what has been selected.
That's what's in the statute. Let's see here. The email imply that there's a change to occur with the portal. Is that correct?
No, no changes. I've met with our developers, and right now there are no changes that we see coming forth.
Yeah, that said, I think every time we do one of these webinars, we do learn a little bit more and see the friction points. And so, if optional fields and certain data collections would help us gather information about, useful things, we certainly don't want to make it any harder on mediators and arbitrators. Yeah, all the questions that you guys have had, I think, grist for the grist mill for sure.
Yeah, and just to tag on to what Bob said, if you have suggestions, send them to us. We do collect suggestions, and when we do meet with our developers, sometimes they're like, "That's absolutely not possible." But some things that you see, the way the portal works right now, that's not the way the portal started. So some of those changes have been made based on suggestions from submitters, facilitators. So it's a work in progress. So if you have suggestions, definitely email them to us.
And related to that, the department is likely to do some rulemaking on the mediation arbitration IDR rules this fall and winter. I don't anticipate those rules to be, massively changing or any major changes. They hope to address a couple very technical corner cases with coverages and things. But rulemaking is governed by the administrative code and the APA, and we love the transparency and feedback. And I think folks who are on this call would be excellent, well-informed folks to participate and provide comments on those rules. So stay tuned for that. That should be in the near future here.
Hundreds of witnesses standing by. All right, next question here. If the final teleconference offers do not match the final offers in the submissions for an arbitration because the parties negotiated in between, do we use those final offers reflected in the submissions, or can we still use only those reported in the teleconference box of the portal?
Cindy, do you want to take that so you don't have to only answer fair health questions?
Sure. Well, it's
There's
interesting.
some more.
When we were when we were building the portal, that's something that we deliberately built in to the portal feature. So we understand that people make mistakes. Also, sometimes things can change from one point to the next, or what have you. So the reason why that's an open field for you to enter data is because, you know, sometimes either you might find that the health plan didn't record the information correctly, or like the question mentioned, you know, something may have changed between the point that it was entered and, you know, what the arbitrator actually receives. So yes, I guess the answer would be the information that's returned directly to the arbitrator as the final offer should be what's entered into the portal.
Okay, sounds good. Next question. I've had a couple of plans in mediation refuse to provide information because they say it's proprietary or contains trade secrets. Any recourse there? Any thoughts on that?
Well, Bob's generally the guy that keeps me out of legal trouble, so I guess I'll defer to him on that.
Yeah, that's interesting. I don't know if any of the 10 factors required by statute are automatically going to include proprietary information, but you know, I suppose parties are, you know, if they don't want to provide some of that information, if they think it's proprietary, it's probably not an easy way to suss that out. And I would just say that, you know, the information that they provide is their kind of opportunity to kind of weigh in on what kind of final numbers should be in the decision. So I think that if they're unwilling to provide that, I think they're just kind of forfeiting that opportunity there. So just do the best you can with the numbers that are available.
Okay. I recently called Fair Health about the large drop in the 50%, and they told me that they changed the way they're computing it. I guess that's just passing on some information to us. How can we get the data that Cindy talked about in the IDR compared to the Fair Health data? That question makes sense to you, Cindy?
Yeah. Well, it's kind of interesting because there's a couple of different things that you can do. So the state of Texas operates something called the Open Data Portal. And I believe it's data.texas.gov. I think that's the actual website. And so the agency has put a lot of data out there for you to kind of make your own reports out of, if you like. IDR is one of the programs that has data out there. It's all aggregated, so you're not going to be able to find anything. We're not able to release anything that's not aggregated. So by that, it's we mean you're not going to be able to see specific health plan information or specific request information other than just sort of the large numbers. But that's one place where you can get it. Another place would be, you know, we do webinars like this one from time to time where we like to present program updates. And then a third thing would be that, you know, I was mentioning the annual report that we'll be composing. We're in the middle of working on that right now. So toward the end of the year, you'll see the most updated edition of that, but the previous versions are also on our website. So hopefully that answers the question.
There is some data out there to look at anyway.
Yeah, lots of it.
Next question. I'm sorry. Do the parties have to choose from the list of 5 facilitators that's provided to them, or can they choose any mediator on the approved list?
So we have had situations where both parties agreed to use a specific mediator, but that is, again, when parties contact us, you know, reach out to us proactively and say, hey, we agree to use this mediator. That's the only time that happens. We don't have a way to do that with arbitrators, but that is the only time. And to be honest, I have not seen it happen very often.
Okay. Here's another question. Would TDI consider setting a deadline for each party to submit their position papers. As often, I don't get anything until the last day before the deadline.
Again, Bob, if you want to help me out with that, but I don't think we have the power to do that.
It's not in the statute.
Yeah, it's not in the statute.
I will say the rule does say that parties need to respond to your requests. It probably would be a good practice to reach out early on in that period and say, I'd like this information by whatever date you want. I think that's probably will probably help things out.
Okay. I'm going to go for another 5 minutes if that's okay with everybody. Is there an opportunity for mediators to become arbitrators, or is the list just closed right now?
At this time, the list is closed.
Okay. When generating the list of 5, do the names change, or do the same 5 neutrals end up on the same list all the time?
No, again, as people
Right.
take themselves out of rotation and go into rotation, it can change.
Okay. When I have a case involving potential bad faith, I'll usually note the issue in my notice of decision and copy TDI, IDR. Is that going to be sufficient notice to the agency?
Yeah, and again, it helps if we get an email, just because we'd like to see what's taken place as far as what emails went back and forth. So that would help us as well. Like I said, it's a good first step, but yeah, as practice, it would help us if you send us an email as well.
Okay, thank you, sir. When a party settles and one party is paid but the other has not, should I refund the party that is paid or continue to seek payment from the other side? Thoughts there?
So the payment is due upon assignment. So again, it's up to you. If you feel that you should or want to refund the money, that's totally up to you. We're not going to tell you to refund the money because one party paid and one didn't. Again, our fallback position is always, the law says payment is due upon assignment.
Okay, here's a good question. Earlier, you stated that the mediations need to take place if they've been scheduled for legal reasons. If the parties contact the facilitator prior to the mediation date, stating that they've already resolved the case, what's our next step?
I guess maybe Cindy, you can back me up or jump in, but I guess my question would be like, what does that mean? Like what what do they mean by they have already resolved the case, right? So I'm not trying to be coy, but it just depends. It's tough to answer that without knowing what that means.
So maybe get in touch with us and we'll discuss the particulars.
Sure, and the report gives the ability for you to indicate whether or not there was a settlement, and so that's, I guess, just like Marcus, we would want to know what they actually mean by that statement, resolved. Yeah.
Yeah.
But best case scenario, you get paid because it was assigned and it was settled before you had to spend time on it. And
There you go.
hey, there you go.
Here's another question for us. If I have been assigned multiple matters with the same parties, if they want to mediate all the matters at the same time, should I only accept a fee for one matter as originally assigned?
The fee is per request again.
Per request.
So if you choose to, have one meeting and tell them like, hey, we'll only have one meeting and you only have to pay me once, that's totally up to you. Again, we're not going to tell you how to collect your fees, but we want to make sure you get your fees, but that is totally up to you.
Do we anticipate any legislative changes coming up?
Yeah, that's a good question. I don't think we can predict that, but I will say that, the 2021 legislature didn't have a whole lot of changes to most of these. I think there just wasn't a whole lot of data at that point, but I think we've got a lot more data and a lot more kind of feedback. So as we do our annual report, I think the legislature will look at that. I think the legislature will look at the Federal No Surprises Act stuff.
Right.
Pre-filing is only 3 months away. I don't necessarily think a bill will be filed the very first day, but I suspect some things will be filed, and the process will maybe somewhat different come next summer. So, but for now, nothing major is going to be changing.
Yeah, there's more experience and data to look at and make adjustments. This may be in the data slide, Marcus, but how many arbitrators do we currently have, including those that are both arbitrators and mediators?
It is in the data slide, and it's roughly 300.
All right. All right, there's my signal. It is 3:15. We're going to wrap it up right there because we're well beyond our time. But of course, if we didn't get to your question today, or you think of something else that you need addressed, please send them to the email we mentioned, idr@tdi.texas.gov, and we'll try to get back to you with an answer if we can. And that's it for today. Thanks for joining us again. We hope you have a great rest of your day, and we'll see you at the next TDI webinar.